If not so, no new member in this family. Advocate Mutweni, what is the position?
Good morning, Chair. Good morning, members of the panel. Chair, following the discussions in the chambers, more so the directive that I should inquire from Advocate Riley whether isn't there a possibility that we can at least start. I'm saying following the directive that I should inquire from Advocate Riley whether there's a possibility that we can start with her evidence. I contacted her and spoke to her together with Advocate Lekgeto, and she says she can avail herself to testify, but she requires more time to get herself ready, and then that she'll be available from 2:00 this afternoon. So the request is to us that we stand down till 2:00 for her to commence with her evidence.
Is she still preparing the supplementary statement, as you mentioned?
Both preparing herself to start testifying as well as the statement. So we will proceed up until the parts that she believes will be affected by the supplementary statement. I've not seen the supplementary statement, but she's prepared to go as far as we can today, Judge. Chairperson.
We are made to understand that the supplementary statement does not relate to the first part of the main statement.
Indeed, so much.
As it has happened with other witnesses, is the supplementary statement affecting matters that could not be dealt with in evidence in chief?
In fact, I asked that, and she says she believes that she prefers to also state that put that in a statement. Because I also asked the same question. Whatever supplementary issues that she would like to raise, she could raise that during the testimony. But I was advised that she prefers to address them in a statement.
When do you anticipate will be finished with this witness? Because 1.5 days is now wasted.
Chair, if we start today by 2:00, I'm sure that if we were to adjourn between, say, 5 and 6, I would have covered a greater part. The statement is not long, it's just merely summation of the report. So I would have covered at least between 60 and 70%. I anticipate, subject to what will be contained in the supplemental statement, that I might finish with the evidence either by tea time or at least shortly before lunch tomorrow. But I'll try and be as quick as I can with the evidence to at least cover up for the time lost.
Yes.
I'm trying to understand what is it that Advocate Riley is preparing herself on, because what we are asking her to do is to come and testify on a statement that was long prepared, that she has signed. So I'm struggling to understand. It's not like singing where you have to prepare your voice. It's a statement that she has already deposed to. So I'm really struggling. Why should we waste the whole morning until 2 when she's not, you say she's not working on the supplementary, she's preparing herself. What is it that needs to be prepared?
That's what I was told, Madam Advocate Mary, that she now wants to prepare herself to testify. Because I also thought that she had read the statement, familiarized herself with the statement, and would have been ready to testify as early as yesterday morning. But that's what I was told by Advocate Lekgeto. And I asked whether can't we do it till after tea. They said she need at least until 2:00. That's what I was told.
Advocate Mtsweni, this takes us to what happened yesterday. Yesterday we were told that Advocate Riley is not is not here because she does not agree with the contents of the statement. But today, she's now supplementing and not necessarily saying, I'm discarding that statement and coming up with a new statement, meaning the statement that is already on record still stands.
Yes.
So I really have a difficulty where we as a panel and as an inquiry are going to have to rely on the preference of witnesses. A witness prefers to start at 2, when we know that, firstly, we are statutorily guided within on the time within which to work, and we've had other challenges that brought us to where we are, where now we have to run. We are now even thinking about working beyond working hours, going beyond 6. We've done that 2 weeks ago. But should it be the norm? Because witnesses are saying they prefer certain times to start, or they prefer doing things in a certain way. I don't think that is how we should work as an inquiry.
I accept, Madam Advocate Murray, that should not be, and unfortunately, that's the what was conveyed to me. If it were up to me, she would be sitting there and testifying, but this is what I was told.
You see, what is most troubling for all of us is that this is just not a lay witness. She's an advocate. She's an officer of court. Most of the witnesses who testified, who are not even one witness, not even a lawyer, we never encountered problems with those witnesses. Now, someone who understands court proceedings better, who should be even be more accountable, who can prepare her statements. We have now wasted a day yesterday and this morning, and we are told that the witness prefers to start at 2 o'clock without a clear indication as to why, when she has signed her main statement. We do not take kind to that. You can tell the witness that we expect better from her as an officer of court. We may not be a court, but we expect better from legal practitioners in this inquiry to assist us. Do convey that to the witness. We will convey that to her when she starts, because we don't want to put you in a difficult situation of being a mediator between the panel and her. But we do appreciate, Advocate Mtshweni, your efforts in making sure that we start on time. Yes, thank you very much. Advocate Gaitobi.
Madam Chair, we unfortunately do have remarks to make on this point. And I'm constrained to make those remarks because I'm trying to be as cooperative as I can with Mr. Mtshweni. But I think this is beyond me, and I have to say what Mr. Chauke feels, which he has repeated to us. We don't accept the adjournment of Advocate Riley. We ask the panel should direct her to start now. There is no reason why we are adjourning, no reason at all. Number two, yesterday was extreme disrespect to this panel. I've never seen actually a panel being disrespected so much by witnesses. Advocate Riley was first introduced to us on the 24th of October, 2025. There was a first meeting with her on the 7th of November, 2025. 7th November, 2025. The alleged aspects of the supplementary statements were first introduced in our critique of the report by Mr. de Kock when Advocate Batoyi testified on the 12th and 13th of December 2025. Those criticisms were repeated by Advocate Mayema in February 2026, which is the most comprehensive critique of that report. So yesterday, to learn that she wants to respond to Advocate Mayema, which testimony was given in February 2025, without giving any explanation why she did not respond to Advocate Mayema timeously, is grossly unacceptable. Thirdly, Advocate Riley has given us a statement. She chose what to put in that statement. And no one compelled her to put whatever she put in that statement. Lay witnesses that have come here have supplemented their information. Some of them have corrected what is in the statement verbally. They will say this paragraph is wrong, I beg leave to correct it. The panel has never stopped them from doing that because it's human nature. You see something wrong, you didn't notice it, you correct it.
Well, this is what I've just put to Advocate Ntweni now. I don't think he's in the position to answer for Advocate Riley.
Yes.
I'm not interrupting your counsel, but perhaps without saying end your submissions, perhaps we should work towards finding a solution and wait for Advocate Riley to take a stand. Because I don't see how, when she's not even in the building, we're going to do that back and forth again, sending messages to her, and it is just putting too much pressure on us. But I hear what you're saying, Counsel, and
I'm not going to proceed. Thank you,
please,
Madam Chair.
I request you.
Yes.
I note what you are saying. You know how we feel about this unpreparedness when a month was wasted last year, purely because the witnesses for the evidence leaders were not available. We started with the evidence of Advocate Chauke, a procedure that is extraordinary. But we had to make progress. We are now done with the evidence of Advocate Chauke. You have dealt with all his witnesses. We are now back to square one and are experiencing the same challenges. It is even more disturbing that we are experiencing challenges with advocates who are members of the NPA, who are supposed to be helping us more than anybody else. I request that we pause, Counsel, with respect to you, and find a solution that is not going to cause us more anxiety and distress, and wait for the witness to take a witness stand at 2 o'clock. With that understanding, we will stand the matter down until 2 o'clock. And we hope that Counsel and the State Attorney, that SMWX, will convey our displeasure to your witness. We propose to stand the matter down until 2 o'clock, when we hope that we will not take any other adjournment because of the unreadiness of the witness. We do so.
Thank you, Madam Chair.
Good afternoon, Chairperson and the rest of the panel.
Do you see us?
I can see you, Chairperson.
Yes, thank you. You well?
I'm fine, thank you, Chairperson.
Yes, thank you. Advocate Mchweni, I suppose that we can start. We are going to start with you, Advocate Riley. First, do you prefer to take the oath or the affirmation?
I can take the oath, thank you.
Yes. Do you swear that the evidence you are about to give will be the truth, nothing else but the truth? If so, raise up your right hand and say, "So help me God."
So help me God.
Yes, thank you.
Yes. Good afternoon, Advocate Riley.
Before you start, Counsel, there are just few matters that I would like to ascertain with the witness. Advocate Riley,
Yes, Madam Chair.
first we want to thank you for having made yourself available to come and assist us as a panel in this inquiry. But I must say that we have started late and lost yesterday because seemingly you encountered problems with regard to your flight. Is that correct?
That is correct, Madam Chair. If I can just explain, we try to comply with the due date in respect of my affidavit. We finalized it on the 6th of April, the Monday. I tried to as much to comply with the due date. However, I felt that there's potentially a possibility that I can supplement my statement, which I was not, in my opinion, was a bit incomplete because I wanted to deal with Colonel Magena's evidence, which I didn't have an opportunity to do so. That's the one aspect. And then I was told on the 6th of April that since a retired Major General Boyson did not submit his affidavit and he was not able to testify, that I will have to avail myself on the 8th. So I did try to get a flight. The only flight that was available for the 8th was on the at 11 o'clock, which basically meant that it would have taken me plus minus 2 hours to get there, around about 1 o'clock, and then from there travel to Pretoria. I do apologize once again to the panel. It was never intended to be disrespectful to the panel. I also want to apologize to Advocate Chauke as well as his legal representation and everybody else involved in the inquiry.
Thank you, Chair. But given that you say you missed your flight yesterday and the earliest available flight was 11, wouldn't it have been prudent for you to make the same arrangements and connect virtually so that at least we salvage what was left of yesterday's day?
I do understand what you say, Chairperson. We didn't discuss that option.
I'm not sure to what extent you wanted to deal with Captain Mangena's report, as we have not seen your supplementary affidavit. But are you aware that you can supplement your statement whilst you are under oath?
That is correct.
Would indeed be possible then, if we would have started at least this morning, for you to do so?
That is correct. I do apologize for that oversight.
Wouldn't it have been easier for you, instead of writing a supplementary statement, to simply start and say whatever you would like to say in relation to the part that you sought to add to your statement, as it often happens?
I could have done that as well, Madam Chair.
Did you consider that, or is something that at that time it escaped your mind?
I have to admit, Madam Chair, it wasn't a consideration. But I do understand what the Chair is saying in connection with that, that I could have considered that option.
Yes, we do understand that initially Major General Boysons was lined up to start testifying yesterday, but for reasons that were beyond our control, we couldn't, and then you were lined up to testify. When first were you consulted with by one of the evidence leaders?
Madam Chair, in November, there was a brief interaction between the evidence leader and myself, as well as Advocate God Halley. It was on a Friday before the inquiry started. And then I was informed that on that Friday afternoon, we just briefly chatted about the inquiry, that I would then have to testify at a later stage. The undertaking was from the evidence leader that he or she will arrange consultations with me after our first meeting. On the 5th and the 6th of March was the first time that I met the evidence leaders for consultation.
After having met last year, November?
That is correct, yes.
Were you familiarized with the terms of reference in November during your meeting?
Not at that stage. I went to go read it up myself.
And having been now aware of the contents of the terms of reference, why was it difficult for you to finalize your statement as early as at least beginning of the year?
I had attempted to start drafting my statement around about the beginning of February.
Councillor, I asked this question because you are an advocate, and I'm sure it would have been easier for you to prepare your own statement, having been closely attached to the history of the matter and being fully aware of what is the subject matter of this inquiry. Am I correct?
That is correct, Madam Chair.
That would have made it even possible for you to could have testified even earlier than now, had that happened.
That is correct, Madam Chair.
We were supposed to have received your statement on the 4th, on Thursday last year, before we adjourned for Easter. That did not happen despite our direction and that undertaking. Do you know precisely why did that not happen? Was it because of any omission on your part?
I received a draft on I think it was the 2nd. And then we, together with Advocate Lugetu, we worked on the draft over the weekend.
But I want to know, why is it that we did not receive your statement last week, Thursday? Were you consulted before last week, Thursday, or had arrangements been made with you that your statement will be finalized by the latest Wednesday last week?
I received the draft statement on the 2nd from Advocate Mshweni.
Did they tell you that we expected to receive that statement on Thursday last week?
He mentioned it in his email. That is correct, yes.
We waited the entire weekend and only received that statement on Monday, the Easter Monday.
That is correct, Madam Chair. There were also certain documents, annexures that I was required to copy.
Yes. You see, Advocate Riley, I'm mentioning all this because we are running behind schedule.
I apologize.
Last year, we lost more than a month because of some delays occasioned by the failure to produce statements on the side of the evidence leaders. We are now back to square one. We are made to wait again for statement from witnesses like yourself. And I am talking to you as I do because you are an advocate. You are in a better position to make our task even far easier in terms of availability of statements and cooperation.
I do understand, Madam Chair.
Advocate Riley, you became aware of the fact that evidence leaders had identified you as one of the witnesses in this matter as far back as October or November last year. Is that correct?
That is correct, yes.
Yes, and I hear now you're talking about Advocate Hali, but did Advocate Mohlamunyani and Miss Tulare contact you or actually meet you in Cape Town in order to inform you that you are going to be a witness in this case, in this matter?
I think the meeting of November was to ascertain what do I know about the matter and to determine at a later stage where I'm going to testify. And on that Friday, the undertaking was that we would meet again to discuss this matter. It was a very, sorry, apologies.
Do complete your answer.
No, I just wanted to say it was a very brief interaction. What I do know is there was consultations with other witnesses, such as retired Major General Boyson, as well as Kobus Rulolse. So when they called me on the Friday, I know that they had flights the afternoon. So our discussions around this matter was extremely brief, and I was then told that they will contact me at a later stage.
Yeah, we've not as yet started obtaining your evidence. We just want to understand as to the history of your meeting with them. And I try by all means to ask simple questions so that I get simple answers. Compound answers are a bit problematic. So, shall we continue with simple answers to simple questions?
Apologize? Yes, thank you.
Thank you. I have asked the persons that came to you in Cape Town to meet you about this case are Advocate Mohlamunyani and Attorney Tulare, who came in their capacity as evidence leaders. Is that statement correct?
That is correct, yes.
Right. And these people, when they came with prior arrangements. You were expecting them then.
That is
correct.
That is correct, yes. Yes.
And it was, you also knew that it was in connection with this inquiry that
is
we
correct,
are currently holding. And you immediately or soon thereafter, because from then you knew you were going to be a witness, you then familiarized yourself with the terms of reference.
That is correct, yes.
And you became aware that during the process, circumstances then dictated that we lead or we allow the evidence of Advocate Chauke to be led before the evidence of the NPA and any other interested parties is led.
That is correct, yes.
And you were aware of, whether in depth or just at high level, the circumstances that led to that approach then being invoked, the approach of getting Advocate Chauke's evidence being presented before the NPA's evidence.
That is correct, yes.
And with that knowledge, you did not then try to alleviate the problem by preparing a draft statement for the evidence leaders. And I'm saying for because of lack of sufficient vocabulary, but that statement would be your own statement.
That is correct.
Why did you fail to do that?
I have on my own started to draft my statement based on what Advocate Hali has requested me to do so. So when I met with the evidence leader, I was able to give him the dates, everything in connection with how this process started, as well as started to collect certain documents that might be relevant to the process.
Just remind me, when you say you started to do this, collect documents, draw statement or a draft statement, when did this happen?
That was around about February.
Round about February.
That is correct, yes.
And we are where we are today in terms of your participation.
That is correct, ma'am.
Well, I keep on hearing you throwing in the name of Advocate Hali. I don't know as to whether is he the person that you were consulting with, communicating with, or was there an engagement with evidence leaders? Evidence leaders that have come to be known as persons that have come into contact with you by this panel are Advocate Mohlamunyani, Attorney Tulare, and Advocate Mutsweni. Yes, has it happened? Because that's what is our understanding.
The first time was in November, and then again I met Advocate Msweni.
Yeah, I did not ask about the time. I just said, is it correct that, even to your knowledge, the evidence leaders are the three that I have mentioned?
That is correct, yeah.
And you understand the delay that appears to be coming from the side of the NPA, as you have been following
That is
this
correct.
process. You are quite aware of that.
That is correct, ma'am.
Okay, right. Thank you very much. Thank you, Chair.
Thank you.
Advocate Riley, you say you received a draft statement on the 2nd of April.
That is correct, yes.
And your statement is about 41 pages,
That is correct, yes.
excluding the annexures.
That is correct.
How long did it take you to settle the statement, given that most of the information, as you've just said, you had it in your possession, you had given it to the drafter of the statement, and I take it it's Advocate Ntweni. How long then did it take you to settle your statement?
We are sending my first corrections or on the 2nd.
On the
And then I
same,
received it back. Yeah,
on the same day, the 2nd.
that is correct.
Okay. And then you received it back?
Yes, and I worked on it further.
Okay. And when did you send it? You send the final version?
It was Sunday evening.
What was Sunday evening?
Sorry, can I just say it was Sunday afternoon?
The 5th. Sunday was the 5th.
That is correct, ma'am.
I'm asking this, keeping in mind that you are an advocate. Also that drafting, especially talking about stuff that you have been involved in, it may have been a number of years back, but it's something that after you were told that you're going to be a witness, you must have refreshed your mind. And now, and you knew, I take it that you said it, you were made aware that the statement should have been in by the 4th, and you received a draft by the 2nd, and you only sent back the final draft on the 5th.
There was.
Sorry, I'm sorry I interrupted you.
No, sorry, ma'am, I interrupted you. I just wanted to say that there was also, the final draft was sent on the 5th, the afternoon, but we also worked on it the day before.
Mm-hmm. So the fact that we received your statement later than what the directive had said cannot be put on the door of the evidence leaders. It was because you were still working on the statement.
I will concede to that, Madam Chair. That is correct. It meant that some of the dates I had to go back to emails or to refresh my memory from other documents as well.
Yeah, so what I don't understand is that you got the draft on the 2nd, and there was that toing and froing, which is normal when an affidavit is being drafted on behalf of someone. And then after we received the unsigned draft, which was fine, showing that you are keen to assist us, and then we received your signed draft. But then come the day of you testifying, you are not ready, you want to make certain amendments. The following day, you still want to prepare yourself. How so? Why would you want to take a day and a half to come and testify on a statement that you finalized on the 5th?
I can't take it further, Madam Chair, except to say that I considered the evidence of Colonel or Captain Mangena to be very important. So what I did was I had to study his evidence and then obviously looked at some of his reports to determine whether those reports we have actually received. And that basically meant that I had to go back to all the dockets that were actually on disk and be downloaded to go through those dockets to determine if we have received a statement to that effect. And I did indicate that I've wanted to draft a supplementary statement that included that information regarding Colonel Mangena's evidence.
Okay, thank you. I think that point has already been canvassed by the chair with you. I don't need to go back because you could easily supplement your statement while you in the middle of your testimony, but you have already responded there too. Thank you.
Thank you.
Advocate Riley.
Yes.
We have noted and accepted your apologies.
Thank you, ma'am.
We are going to proceed, but we may proceed with your evidence until a little late today to make up for the time lost because we don't have much time.
I understand that, Madam Chair.
When we pause for tea later at about 4:30, if you need to make any arrangements concerning your personal matters, do so bearing in mind that we may work until slightly late.
Oh, thank you for that indulgence. I will do so.
Yes, thank you. Advocate Msweni.
Thank you, Madam Chair.
Maybe we should make it clear right at the start that as you have familiarized yourself with the terms of reference, you know precisely what the issues are, correct?
That is correct.
And you can accept for now that we have read your founding statement and the annexures.
I accept that.
You may proceed, Counsel.
Thank you, Madam Chair. Advocate Riley, you should have before you or with you a document which starts at SR 0001. Do you have that?
That is correct, yes.
And that document goes all the way to SR 0040.
I confirm that.
Now, on page SR 0040, there's a signature there.
That is correct, yes.
Is that your signature?
I confirm that it's my signature.
Yes. Now, before I move on to the next question, is there anything in that document, in your statement basically, that you would like to correct, that you believe should be corrected at this stage?
That is correct. Just one grammatical error in paragraph 9. It should read, I'm further advised.
And then is there anything else again?
Thank you.
Yes. Now, you have read the document, is that correct?
That is correct, yes?
Yes. I have noted that the document, although provision is made for it to have been deposed to before a commissioner of oaths, that has not happened. Is that correct?
That is correct, yes?
But be that as it may, do you confirm that the contents of the statement are correct and that they are binding on your conscience?
I do confirm that.
Thank you. Now, we then go on and deal with your statement. At paragraph 1, you tell us that you are in the employ of the National Prosecuting Authority as a Deputy Director of Public Prosecutions and attached to the Office of the Director of Public Prosecutions for the Western Cape. Is that correct?
That is correct, yes. I confirm it.
Advocate Mtsweni, I'm sorry to interrupt. You've just taken the witness through, cursorily through the statement to indicate what is it that she may not be happy with in the statement, and she only made one grammatical correction.
No, madam, I said corrected, not added. I said corrected.
Sorry?
I used the word corrected.
Corrected.
Yes.
And now she's just confirmed that the statement is correct and it's binding on her conscience. Yesterday, we were told that she was not ready to testify as she was not happy with the statement. And one would have expected that she would say, I'm not happy with paragraph 14, let it be scratched out, or paragraph 32, or something. What is it that she was not happy? Maybe let me direct it to you, Advocate Riley. Yesterday, we were informed that you were not ready to testify because you were not happy with the statement. Now, you've just confirmed that you've read the statement and the allegations are correct and it is binding on your conscience. What is it that you were not happy with that made you not to testify yesterday?
I think perhaps the word happy is not how I used it. I indicated that I feel that there are certain aspects of my statement that was not completed, and I already indicated that was Colonel Magena's evidence. However, the chair has corrected me in saying that I could have filed a supplementary statement even if I am under oath and busy testifying. So I acknowledge that I was wrong in that regard.
Thank you.
Yes.
Proceed, Councillor.
Thank you, Madam Chair. Now, Advocate Riley, we then move on to paragraph 5 to 7, where you tell us your understanding of the terms of reference of this panel. Is that correct?
That is correct, yes.
And you tell us that your understanding is that the panel is whether or not Advocate Chauke is fit to hold office of the Director of Public Prosecutions for the Office of South Gauteng Division.
That is correct, I confirm. That is what I read.
And in the main, what the Commission has to determine is whether or not Advocate Chauke supported the decision to prosecute Major General Boysen and the members of the Cato Mena unit on racketeering charges when there was no evidence justifying the prosecution. Is that correct? Is that your understanding?
That is my understanding.
Madam Chair,
Please, gentlemen, one of you must come forward to assist.
Thank you, Madam Chair. And then at 7.3 is your understanding is whether or not Advocate Chauke attempted to have the racketeering charges against Major General Boysen and the members of the Kekana unit reinstated by the then National Director of Public Prosecution, Mr. Ngasana, despite or notwithstanding the fact that there was no evidence justifying the institution of the racketeering charges against them. Is that correct?
That is what I read, yes. I understand that.
Yes. And or at paragraph 8, you tell us that you've been advised further that there's already evidence that Advocate Batoy in August 2019 withdrew the racketeering authorizations issued by Advocate Abrams, as well as the racketeering charges against Major General Boysen and the Kekana unit.
That is correct.
Yes. Then at paragraph 9 and 10, you tell us that you were part of the team that drafted the report titled Reconsideration of Authorizations in terms of Section 2(1)(e) and F of the Prevention of Organized Crime Act 121 of 1998. Is that correct?
That is correct, yes. I was part of this team.
Yes, and that team is now known for the record as the de Kock panel.
That is correct.
And the report that you referred to is the one that is titled SR1 to your statement.
That is correct, yes.
Can you just tell the panel as to who were your core panel members?
The chairperson of this panel was Advocate Rodney de Kock, and then Advocate Ivy Tenga, Advocate Elijah Mamabolo, and myself.
Now, can you tell the panel what was Advocate de Kock's position and where is he now?
At the time of the drafting of this report, he was the DPP of the Western Cape and subsequently became the head of the NPS at head office. Advocate Ivy Tenga was also a DPP, but she was in a different province in Limpopo. Advocate Mamabola used to be at head office in the National Organized Crime Division, but at the time of drafting this report, he was at SCCU in Pretoria. Advocate de Kock is deceased. He died in last year, in January 2025. And Advocate Mamabola is also deceased. He died, I think, during the COVID period in 2020.
Thank you. Now, just before we delve into the report, at paragraph 14 to 17, you deal briefly with your career highlights and growth within the National Prosecuting Authority. Is that correct?
That's correct, yes.
And
That's correct.
perhaps, and at paragraph 14, you raise security measures which prevent you from setting out your full personal information. Is that correct?
That is correct, yes.
Are you comfortable telling the panel why you're not comfortable with that?
In these matters that we are dealing with currently at the organized crime component, we have quite a number of people that are currently under protection as a result of the work that they do. I myself was also under protection for 18 months, and that is primarily the reason why I would not want to divulge personal information about myself.
Yes. But you then at paragraph 15 tell us about your career. And
That is good.
And you tell us that you graduated with an LLB degree from the University of Western Cape in 1993.
That is correct.
And then you then joined the Department of Justice as a prosecutor, where you prosecuted up until 1999.
That is correct, in the Magistrates Court, Wynberg as well as Strand, yes.
Yes. And then you then joined the DPP's office as a state advocate in 1999 and was elevated to a senior state advocate in 2001.
That is correct, yes.
Yes. And then you, on paragraph 17, you tell us that you then joined the organized crime component where you remain to date. Is that correct?
That is correct. That is
Now-
correct.
Now, and can you just add paragraph 17.1? You tell us what is it that you do your functions mainly within the component. Can you just summarize that for the panel?
First of all, managing and dealing with prosecution of organized crime within the terms of POCA and other related legislation. We also deal in the context of our work, because we're dealing with criminal networks, analyzing and submitting applications for authorizations in terms of Section 2, subsection 4 of POCA to the DPP, who in turn will submit same to the Office of the National Director for authorization. Then lastly, part of my duties is also as the Deputy Director of Public Prosecutions, is to assist, supervise and coordinate prosecutions, including analysis of evidence and docket, as well as to assist and guide junior prosecutors, which include state advocates dealing with matters that fall within our mandate, which also will include then racketeering.
Yes. And then from paragraph 18, you going down, you set out the circumstances that led to the panel being constituted.
That is correct, yes.
And you then tell us how then you found yourself as part of the DECOC panel at paragraph 38. That would be on page
That's correct.
SR 001. Can you
That
just
is correct.
Can you just tell the panel how it then came about that you found yourself being part of the DECOC team?
In October of 2018, of the organized crime component, I think it was during the first.
Advocate Riley, if I might just
Yes.
interject, you froze
Yes.
just as when you were talking about October 2018. Can you just go back and start from there? Repeat what you were saying?
Okay, I will do so. During October 2018, I became the regional coordinator of the organized crime component after the regional coordinator, Mr. Livingston Sakata, left. It was during the first week of April, a couple of months after I became the regional coordinator. Advocate de Kock called me to his office. He then informed me that he has received a request from the NDPP to put together a team or a panel to do a review of the evidence and to provide a report or opinion on the validity or otherwise the authorizations instituted by Advocate Sean Abrams. He indicated to me as my DPP that he has recommended me to the NDPP as one of the members of the panel, which I accepted.
Were you given an option to say no?
It is the DPP of the province, so it would be rather difficult unless you have good and valid reasons why you cannot be part of the panel. But otherwise, I accept it.
Yes. And then what then happened following thereafter you've been informed by the Advocate de Kock that he was going to recommend you to the panel?
I think I didn't hear anything. Around about the 9th of April 2019, I was emailed a memorandum from the NDPP, Advocate Patoy. I see the memo. The memorandum was also sent to other members of the panel, which included Advocate Mamabola, Ivy Tenga, Advocate Tenga, as well as Advocate Akok.
Yes. And the memorandum, is that the one found as Annexure SR3 on page SR 1076?
That is correct, yes.
Yes. Now, that memorandum contains what one would call the terms of reference of the panel or the mandate of the panel. Is that correct?
I will agree with that. That is correct, yes.
Now, if you can you just read that into the record for the panel and all the members and everyone else?
That is correct. Advocate Abrams had authorized 2 separate racketeering prosecutions in terms of Section 2(4) of POCA. The memorandum said that the defense has brought an application to have the authorization set aside, and the NDPP was cited as a party. As the new NDPP, she was in the process of considering the matter because, amongst others, the fact that the NDPP was cited as a party and the implications the matter might have for the NPA. She further stated that she has taken note of the controversy surrounding Advocate Abrams' decision to authorize the 2 racketeering authorization, and that this decision has also informed the approach that has thus far been taken in the application. She further stated in this memorandum that as the new NDPP, she must be satisfied that the prosecution on the racketeering charges in this matter were justified, and that the ultimate decision rested with her, who will inform the approach she takes in relation to the application. She further stated that this case presents certain complexities and dynamics which could also affect, my understanding was, future racketeering authorizations in general. And then it was stated in the premises, we were requested then to peruse all the evidence and other relevant material, and thereafter furnish a well-reasoned and motivated opinion as to the validity and appropriateness of the decision by Advocate Abrams to authorize the racketeering prosecutions in terms of Section 2, subsection 4 of POCA.
Yes. And then at paragraph 40, you then tell us what the mandate of the panel was according to your understanding, and you summarize that as being whether there are reasonable prospects of successfully prosecuting Major General Boysens and the Kekana unit on racketeering charges. Is that correct?
That is correct.
Now, we understand that in the indictment, over and above Major General Boysens and the Kekana unit being charged for racketeering, they were also charged with certain underlying predicate offenses. Did you have a mandate in relation to those predicate offenses? Meaning, were you expected to provide an opinion on the merits or the demerits or the sufficiency or otherwise of the evidence in relation thereto?
The 23 dockets, which basically constituted the underlying predicate offenses, were studied to determine if one of the elements of racketeering is there, that is a pattern of racketeering activities. We were not, part of our mandate was not to determine if prosecution should be instituted or not.
In relation to what offenses?
The predicate offenses.
Okay, thank you. Now we move on.
Counsel, I'm sorry to interpose. Advocate Riley, when you look at the letter by Advocate Batoi at SR 1077, the second paragraph, you can go back to that document, SR.
Can you give me an opportunity to look at it? I will look at it now.
SR3 that Counsel referred to earlier, that
Yes.
annexure. the second paragraph at page SR 1077. Do you see the page?
I do see it, Madam Chair.
In that second paragraph, which reads, in this case, I have taken note of the controversy surrounding Advocate Abraham's decision to authorize the two racketeering prosecutions. His decision has also informed the approach that has thus far been taken in the application. As the new NDPP, in brackets, and now the affected party, did you understand what she meant by the words, now the affected party? What she meant?
I think my understanding was that there's been applications brought against the NDPP and that she is now the affected party in terms of this notice of motions application. That was my understanding.
And given the fact that the authorizations that were later declared invalid following your report were those of Advocate Abrahams and Advocate Jiba, it could possibly have also meant, as the holder of the same office, when she said, now the affected party.
That is correct. It could also mean that.
In other words, the review that you were to conduct were in relation to a decision by the holder of office.
That is correct. Madam Chair.
Held by Advocate Batoyi.
That is correct, yes.
Will I be correct that the office was reviewing itself, its own decision?
If my understanding was, in terms of the NDPP, that she wanted an opinion on whether those authorizations were valid, and I understand what the chair is indicating in terms of a reviewing of the decision. I do, however, feel that she did it in light of the fact that there were several applications, notice of motion applications, and that she had to make a decision as to whether those decisions were valid or not.
Yes, that's my point. Is the NDPP, being the holder of the same office, reviewing, if I may put it that way, her own decision as the NDPP?
Of a past NDPP.
Yes.
Yeah.
If you can enlighten me, is that procedure permissible? That the incumbent of an office, holder of an office, can review his or her own decision by virtue of the fact that his predecessor or her predecessor had taken a particular decision, and could then review that decision by seeking an opinion and taking the decision that was taken? Does the NPA Act allows that?
I can't point towards the NPA Act that allows her to review her predecessor's decision. However, she, in light of the fact that she was involved in the notice of motion applications, I I understood it that she had to make a decision as to how she will deal with these applications. And that stems from her decision whether to look at whether those authorizations were valid or not.
Yes, I do understand about the pending litigation, but I just want to ascertain whether, in terms of the functus officio principle, she could do that. And if you can enlighten me on that.
She was reviewing the decision. It's in terms of a new NDPP, in terms of whether that decision was correct or not. And she was entitled to do so.
In terms of which provisions of the NPA Act?
I can't. I will have to go back to the NPA Act to be able to give the chair the specific sections in terms of that.
Yes, Council, if you may revisit that earlier, I'll also quickly look at the Act and see if there is such a provision, but the witness being an advocate within NPA, I think is better placed to assist me. You may proceed.
Thank you, Madam Chair. Advocate Riley, just on this issue that the chairperson has raised with you, as an advocate with your years of experience, more so having been in the NPA's office, would you accept that irrespective as to when Advocate Batoyi came into office, the decisions taken by her predecessors are regarded as being her decisions?
That is correct, yes.
Yes. Now, in the context... Yes, continue.
And especially in light of the fact that she was held accountable now to explain those decisions, she had to make a determination whether she agrees with it or not.
Yes. But now I just want to, the chairperson asked you a question whether, did you understand Advocate Batoyi to be asking you as the panel to be reviewing her own decision? Is that how you understood it, or is it you understood it to say she wanted an opinion on the validity of her own decision, being irrespective as to who took the decision?
I understand the chair to refer to her reviewing the decision. In respect of the mandate of the panel, we were simply to have a look at the authorizations and then provided her with an opinion, which we did.
Yes. We will come back to the question of Advocate Batoyi's authority to review her own decisions later. But in absence of any questions, Madam Chair, can I move on to the next?
You may proceed.
Oh, I see Advocate Lumera has got questions.
In the same paragraph, the very first sentence, Advocate Batoyi takes note of the controversy surrounding Advocate Abraham's decision in terms of racketeering authorizations. Were you aware of any controversies around the decision by Advocate Abrahams? And I'm asking you this because my understanding is that the authorization is within the realm of the NDPP, it's a national competency. And if one has regard to the fact that Advocate Batoyi came in February 2019, and this memo is dated the 9th of April, which is plus minus 2 months since she assumed office. Would you care to enlighten us about the controversy if you are able to do so?
The only controversies that I'm aware of is what I've read in the newspapers, as well as ongoing cases that happened regarding the notice of motion application brought by the persons that were involved in this matter. I didn't have personal knowledge or was part of any decision making in that regard, but from what I've read in the media and obviously certain court judgments.
Did you read, whatever you read in the media, was it specifically referring to Advocate Abraham's decision, or it was just you read articles about the Ketomena and whatever was happening at the time?
It was relating to the notice of motion applications and the fact that these authorizations were that the group Boyson and others were not happy with the racketeering authorization. So I was well aware by reading in the newspaper certain judgments in this matter, as well as decisions at that stage, either to withdraw some of these racketeering authorizations, since it's very much part of our environment, the organized crime component, that you obviously acquaint yourself also with these types of cases.
So you read what the applicants were actually saying and complaining about in their application against the NPA and against their authorizations?
No, I didn't read the applications. I said what I've read in the media and what is going on. And then in respect of one judgment that I've read, that was the Juba judgment, what is commonly referred to as Judge Auburn's judgment.
Yes, I didn't say you read the application. Maybe you misheard me. I said you read about what the applicants were saying in the media, complaining about the authorizations and how maybe wrong the authorizations were issued.
That is correct, yes. It was in the media.
Okay, thank you.
Thank you.
Now, Advocate Riley, just to put this matter to bed so that we move on swiftly, you said that the DPP has got the power to review her own decisions, and you said that's in accordance with the NPA Act. I am looking at Section 22, subsection 2 of the NPA Act, and it lists certain powers of the National Director. And amongst the powers, it says she can determine the prosecution policy and issue policy directives, and may intervene in any prosecution process where policy directives are not complied with, and may review a decision to prosecute or not to prosecute after consulting the relevant director and after taking representations within the period specified by the National Director of the accused person, the complainant, and any other person or party whom the National Director considers to be relevant. Is that the power that you say empowered Advocate Batoyi to review her own decision, as she had asked the panel to do that?
That is correct. It's partly. She has asked us for her opinion. She will then make a decision. And based on that decision, she is then required to consult with others, such as the family members, or to make representations or to accept representations in respect of that decision.
So did you then, as a panel, understand the authorizations by Advocate Abrams to have been a decision to prosecute?
That is correct, yes. Whether to institute or to withdraw in terms of our policy directives as well.
No, I'm just talking in the context of the authorizations, the validity of which you were to provide an opinion on. did you understand those authorizations to be a decision to prosecute within the context of Section 22, subsection 2, subparagraph C of the NPA Act?
That is correct. To institute or decide not to institute a prosecution.
Yes, thank you. Are there other questions on this part, Madam Chair? Yes.
Did you understand that to include the power vested in the National Director of Public Prosecution in relation to the POCA authorizations?
That is correct, yes. That is a prosecutorial decision, whether to institute prosecutions in terms of Section 2 of the Act.
Which is the power vested only upon the same NDPP?
That is correct, yes. That is the only, you cannot proceed with those prosecutions unless it has been authorized by a National Director of Public Prosecutions.
Once authorized by the NDPP can then later review himself or herself?
That is correct. It happens often that once you receive the authorizations, you will go back to the NDPP if the evidence has changed, or even if you feel that your witnesses are no longer available and that you cannot proceed on those charges. You ordinarily will submit an application to the NDPP to review her decision to withdraw the Section 2 authorizations.
This matter, does it then follow, if you are correct, that the withdrawal of the authorization, having found that the two earlier authorizations were invalid, were in accordance with Section 22(2)(c? Is that what you're saying?
That is correct. In terms of reviewing your decision or withdrawing your decision once you have made it in terms of Section 2.
Thank you, Madam Chair. Having analyzed that, we then move to at page 4, SR 0014. You then tell us how, as the panel went about delivering on your mandate. Is that correct?
That is correct.
Yes, and you tell us that you were provided with the dockets, which dockets were given to you through in a form of a disc by Advocate McAdam.
That is correct.
Yes.
What has happened is that we were all in different provinces, basically, except for Advocate de Kock and myself in the Western Cape. So we wanted to proceed as soon as possible with the reading of the dockets. And I think at one stage I do attach the correspondence to it, how we tried to get hold of the dockets. So eventually the suggestion was that it must be couriered to us in the form of disc to each panel member, and that contained in scanned copies of the dockets that we were supposed to assess, which we then downloaded on our computers, which I did. I downloaded on my computer. And the requirement was that, and the agreement was that each panel member will then individually study and analyze each docket in anticipation that we will have a in-person meeting at a later stage to discuss the evidence.
Yes, and you say they were given, the dockets were given to you in a form of a disc. Now, in the modern technology, disk comes in many formats. There is what we call the USB disk, there is what we call a hard drive, which is a disk, and there is a compact disk. Which disks in this context were you given?
Compact disk.
A compact disk. Yes, and in the disks, how many dockets were scanned in?
I went back and I looked at it. It was about 23 dockets. However, I have to say that in some of the scanned copies, there were other dockets also part of maybe individual dockets, such, like the Durban North or Durban Central dockets. So, but altogether, the requirement was that we must actually look at the 23 dockets that related to the 28 murders.
Yes. Now, Advocate Riley, I'm just going to ask you to go to Annexure SR5.
Can you just give me an opportunity to go there?
Madam Chair, in your volumes, it would be on file 3.
I'm there now, Advocate.
Yes, there's a document called WEC document. Do you see that?
That is correct, yes.
Can you identify what that document and who authored that document?
What happened, it's my work methodology. Whenever I have to make a decision in a matter, I prefer to summarize the evidence and potentially identify any shortcomings in the evidence. I look at challenges as well as outstanding investigations. So this was initially authored by me, and then subsequently when I presented my the work document during our in-person meeting, I think it was on the 20th of May, the decision was made that we will then receive comments from the different panel members, whether they're in agreement or not, or whether they can identify anything further that is outstanding.
Yes. Now, the reason I'm asking you to, thank you for the answer. The reason I'm asking you to go to this is ask you to go to page SR 1092.
That is correct, yes, I'm there.
Of the same document, of her work document. You refer there to Mapumulo Cast 9908-2009. That is the docket relating to the murder of Superintendent Konko.
That is correct.
And based on the evidence that has been presented to this panel, that seems to have been the murder that set the entire spree, according to the evidence that has been led by other witnesses. It's called the killing spree by members of the Cato men. Now, the reason I'm asking you this is, Ed, what was this part of the docket that was scanned in on the disk?
No, it wasn't.
Now, when did you for the first time see this docket?
I saw this docket during our in-person meeting from 20th to the 22nd, so it could have been on any of those days. What happened was that you can also check some of my notes, is when you do scan copies, often it's either there's a part of the statement missing, or there's certain statements not following the A section of the docket. So what I've done is that when we went to the 20th of May, for our in-person meeting, and that was my understanding of that meeting, that we will discuss the dockets and the evidence in the dockets, we would also then look at the original dockets. So all the original dockets were actually in the office where we were sitting. That office was, the key holder was Advocate McAdam. So there were quite a number of dockets on the one side of the office. And as we're looking at the individual dockets, we will also then draw the original dockets. So this docket relates to the incidents, to 3 or 4 incidents, and we felt that it was prudent that we actually study this docket to see what was the evidence and how it's connected to the other cases.
Now, is your answer that you saw it for the first time when you had your in-person meeting as the panel in May 2019?
That is correct, yes. It wasn't part of the disc.
Advocate Riley, if you can try to answer the question directly and not give a long answer that is confusing me even more. I was wondering what you were answering as you continued. To just answer a simple and straightforward question by counsel and give the indication when precisely you became aware and not give us a long answer, please.
I will do so, Madam Chair. I saw it for the first time during that 3 days of the 20th of May to 22nd of May.
Yes. And you tell us that that was the first time that as a panel you physically met to discuss the dockets.
That is correct, yes.
Yes. And at paragraph 47, you tell us what happened during that first meeting. Can you just summarize it for the panel?
Okay. During this meeting, after we have been provided the 4 discs, the purpose of the meeting was to study the dockets that were presented to us. So we studied the original docket as well as the B and C sections of the docket in order to fill in some missing gaps in the dockets. We also discussed the docket in terms of the sufficiency of evidence for successful prosecution on the racketeering charges.
What are B and 6 parts? Remember, some of us are not familiar with these acronyms that you use in your office. So if you can just explain.
I will do so, Madam Chair. The A section of a docket is ordinarily where all your witness statements or other evidence are filed. So it's normally filed A1 up until whatever number the docket is part of. The B section is ordinarily communications that the investigating officer would have with informants or letters to different units, or he will even then in that B section make notes regarding any further evidence he must be obtaining. And in the C section is what we call the investigation diary. Therein, the investigating officer will note the investigation, the obtaining of statements. His commander could give him further instructions as to what other evidence he must obtain.
In which part of the dockets will you find experts' report?
If it's evidence before court, it will be in the A section.
The A section.
That is correct, yes.
But if, for instance, a ballistic report was included in the docket, but the matter was not yet before the court in the form of a trial, this very document, the expert report, will still be in the A section, correct?
That is correct.
I'm not running ahead of you, Council. I just want to, now that you're talking about these sections, in the A sections of the dockets that you looked at, did you find ballistic reports in any one of them?
There were several ballistic reports in the docket, yes.
Do you remember in relation to which case numbers?
Madam Chair, I will have to go through SR5, because that is where I commented on each and every docket that I read, whether there was a ballistic report or whether there were any outstanding ballistic reports.
Yes, when you get there at SR5, remember this question.
I will do so, Madam Chair.
And take me through to the contents of those dockets, whether they contained any ballistic reports.
I will do so.
Remember that, Advocate Mchweni?
Thank you, Madam Chair. We'll do so.
Thank you.
Advocate Riley, now that you're telling us that you studied the dockets, perhaps this might be an opportune time just to get your comment on this. During the testimony, and in particular of Advocate Noku, according to my notes, that would have been on day 21, being the 5th of February. And Madam Chair, you'd find that evidence starting from page 221.
What day is that? What day is that?
5th of February.
5 February.
Yes.
Thank you.
Going all the way to I think it'll be page 226. During the evidence of Advocate Noku, and when she was being cross-examined by Advocate Toby, there was a criticism leveled against the panel that in your report, you do not give a summary, a blow-by-blow summary of each docket that you say you looked at. And now I'm asking this in the context of SR5 as to whether is that statement correct that you did not, just simply because in your report give a blow-by-blow account of each or summary of each docket, that you, the panel, did not consider the dockets?
It is incorrect. We had a meeting and we studied the dockets. We went through each and every docket.
Yes. And there were also a number of dockets that were referred to that the report is silent on. And that is, amongst others, Pinetown, Rustenburg, Kwamashu, Phoenix, Begitemba, Eskawini, Tongat. Would you say that you did study those dockets?
We did study the dockets. Our report was a summation of what we thought was prudent in terms of the racketeering and to highlight some of the aspects in some of the dockets. But SR5 or your work document relates to how we actually went through each and every docket and discussed it, analyzed it, and yeah, I would consider that to be proof that we actually went through all the dockets.
But now, just for the...
Of course, unless I'm wrong, the criticism was based on the summary as contained in the report itself. Is my understanding correct?
In fact, I was about to ask that question, Madam Chair. I was about to deal with it.
SR5 was a work document that I'm seeing for the first time. Are you seeing it for the first time yourself?
Yes, Madam Chair.
I'm
Not
saying
today, Madam Chair. I saw
therefore
it before then,
I
but
beg your pardon?
not today, Chair. I saw it before today.
Yes, of course, but
Yes.
it is the first time that it is brought to our attention.
Yes.
Advocate Nkabinde will speak for himself, but my understanding of the questions was in relation to the cryptic notes in the report relating to the contents of the dockets outside of SR5, which I'm only seeing today, or I saw it yesterday, I casually went through it. In relation to the question you put to the witness, as you have just referred us to the transcript, I think it is fair to remember the basis on which the questions were made. Do you remember?
Sorry, Madam Chair, I just want to correct this. I said I don't want to interfere all the time when somebody is leading a witness. Advocate Batoy said she only read the report, the Tikok panel report. So it's that report that was put to her. So there should be no distortion of what questions were put to Advocate Batoy. Advocate Batoy did not say I read SR5.
Yes, Advocate Mchweni says also, Advocate Noko was cross-examined, and those pages that counsel is referring us to and makes mention of the criticism that was leveled against the report, but he bases that on SR5. I am saying to counsel, subject to correction, SR5 was never before us, even during the cross-examination of Advocate Noko. And counsel says yes. So I'm correcting counsel to say it is not a fair question or statement that you're putting to Advocate Riley as regards Advocate Nkwatobi's cross-examination, because it was not based on SR5. Do you understand where my challenge is?
Yes, Madam Chair. To the extent that I, in fact, I may have misunderstood the criticism, I apologize and I retract that criticism. And I profusely apologize to Advocate Nkabinde to the extent that I may have imputed something wrong. It's also an error on his part. I apologize for that. But I do take note that, in fact, he summarizes that at page 226, where, if I might quote, now the reason we had to go through this exercise, even though it is a tedious one, is that if the only thing you read as the NDPP, which is what we know to be the case with Advocate Batoy, she would know absolutely nothing about at least 12 of the dockets, because even on her own best version, she had, other than referring to those dockets, did not analyze a single statement from those dockets. So I think the criticism was that the report itself is silent on those documents, not that the panel did not read the documents. It was that the report itself is silent on the dockets. That's my understanding, unless I'm wrong.
Yes, first of all, let me see. You referred us to this volume, 5 February. Let's just get back to this point because I might have missed something. I don't understand now where we are. You referred us to pages 219 of 5 February transcription. Do you remember?
Yes, Madam Chair.
This was during the cross-examination by Advocate Kwetobi of Advocate Noko. Am I correct?
That's correct.
And there, what was dealt with was with regards to the analysis of the report by, I think there, the report was in relation to the 23 dockets. If you look at 219, middle page. What I'm trying to correct in relation to your question is that SR5 was a working document by the panel. Am I correct?
That's correct from the, yes, Madam Chair.
SR5 was never part of the documents that were presented to us and which were the subject of criticism by Advocate Nkabinde when he went blow by blow in the report itself with the witness. Am I correct?
That's correct, Madam Chair.
It follows then that the question should be retracted and be corrected. You can ask the witness about SR5. It's the first time that we are dealing with SR5.
Yes, Madam Chair, hence I said I retract the question. And I think I wanted to ask a question to the witness as to whether was SR5 ever presented to Advocate Batoyi. Then she can tell us whether Advocate Batoyi had seen it or not. But
was it presented to Advocate Batoyi though, SR5?
that's what I wanted to establish from the witness.
How will she know?
It was their working document. It was the panel's working document.
Whether their SR5 was presented to Advocate Batoyi?
Yes, that's what I want to.
You may.
I see Advocate Mary's got a follow-up question.
Yeah, it's not more of a follow-up, it's a clarification. The questions as posed in cross-examination were premised on page 27 of the report, of the DCOC report, because that's where you find the 23 docket, and there is no explanation on each docket. They were just listed under 4 columns, to 2008, 2009, 2010, and 2011. And if you go to page 221, you will see that they were referring to page 27. You can see that I think it was Advocate Skosana who said something about that page 27. At page 221, I think line 2, 4, 6, 8, 9, 10. I just wanted to clarify that and yeah, that SR5 is new.
Yeah.
Thank you.
I accept it. Now, yeah, the further.
Thank you, Chair. Advocate Riley, this report that was drawn, which is referred to as the DCOC report, for whose benefit was it drawn?
For the NDPP, an opinion was given to her.
And the purpose was to give her sufficient information for her to make a decision about
That is correct, yes.
the racketeering cases. At times, tongue twists are memotswana. Just understand. Okay. And you answered in anticipation and said that is correct.
That is correct, yes, ma'am.
Okay, right. Now, when you looking at the fact that you say the working notes were not part of the report, What went to Advocate Batohi as a report? It's that report that we have, which is signed by Advocate Dikok on behalf of you all. That's what it says at the back. He signed on behalf of you all. Is that correct?
That is correct, yes, ma'am.
In your view, you know, it's very seldom you ask a person to view a document and to honestly reflect on it and tell this panel or anyone whether the information that is in that report that you authored was sufficient to inform the ultimate officer that had the power to make a decision about those certificates. Would you say your report was sufficient to enable the NDPP to make an informed decision? Regard being held to the fact that the working documents were not there. We don't see the summaries. We see just a table that tells us as to which cases were considered. Yes. Can you advise on that?
I would say yes, and I will, if I may proceed to clarify why I say that. On the 2nd of July, that is part of my statement, there was an in-person meeting with the NDPP, which consisted of myself as well as the panel members, where for a whole day we actually sat down, went through the report, discussed with her the various cases, the evidence. We basically did a presentation to the NDPP. She had an opportunity to interrogate the report, but I also think subsequently there was communication in which the panel members were included, and then there was also communications between her and Advocate de Kock, where she had various questions that we had to respond to after she has further analyzed the report on her own.
The evidence before this panel by Advocate Batohi is that her decision to withdraw, to review and set aside initially the certificates was based on the report, and that is purely on the report. She did not mention these other factors that you are now introducing into evidence.
I have email correspondence to that effect, as well as the meeting that took place on the 2nd of July.
Yes, the correspondence can exist, but then the person that made the decision says, I relied on this report. Full stop. What do you say to that?
I won't take it further except for what I know what happened. If she said she relied on the report, then I will accept it. That is what she said.
Thank you. Thank you, Advocate Mtsweni. I'm done.
Proceed, Counsel.
I see Advocate matters for
a
a
follow-up question. At paragraph 52 of your affidavit, you refer to the final report which was presented to Advocate Batohi by the panel on the 2nd of July. That is the very same date that you say there was a presentation that entailed the summation of the material. Is my understanding correct?
That is correct, yes.
So at the end of the day, despite the fact that you made a presentation, what Advocate Batohi was left with is what we have as the report that is now termed the de Kock panel memo or report. So You went, you presented, but this is the final report that you gave Advocate Batohi and which she says she relied on. Am I correct?
That is correct, yes.
Okay, thank you.
Now, can I continue, Madam Chair?
Proceed, sir.
You have skipped, you've now gone to the meeting, the presentation of the 2nd of July 2019. Now, you would say that the presentation entailed a summation of the material and the evidence that were available at the time the authorizations were made. Is that correct?
That is
Now,
correct,
can you
yes.
just elaborate to the panel, what is it that, if you still remember, what is it that as the panel you presented to Advocate
Mtsweni,
Batohi?
you asked the witness whether that is correct, and before the witness answered, you forged forward with your next question.
I thought I understood you to say that's correct.
Thank you.
Yes.
Sorry to disturb you, but...
Yes. Now, can you just, we understand and you can accept what Madam Ramakaka has said to you, that Advocate Batohi never mentioned anything outside the report as being the basis of her decision. But from your side, what is it that, as the panel, you presented to Advocate Batohi when you met with her on the 2nd of July, 2019?
We discussed the report. We discussed the evidence in respect of the racketeering charges, in which you would have included the predicate offences as well.
Did you take her through each and every, did you take her through each and every case and summarized what the case entailed and the material evidence that was contained in each docket?
No, we did not take it through every docket.
Yes. So it would be correct that if you did not present to her the material evidence that was, or you did not discuss with her the material evidence in the docket, that she would not have known unless she would have gone and read the dockets herself.
Can you just repeat that question? I want to understand it.
I'm saying because you did not present to Advocate Batohi a blow-by-blow summary of each case, right? So she would not have known what is in those dockets unless she had gone to read the dockets herself.
I don't think she read the dockets herself. That is, but I understand.
I just answered the question by counsel, if you may repeat.
I'm saying, because you did not give her as a blow-by-blow summary of each and every, what each and every case entailed and the evidence contained therein, which you now know is contained in SR5. Unless she had read the dockets herself, she would not have known what is contained in those dockets.
Except for what is in the report and except for what we discussed in respect of some of the cases, but not all the cases, and yes.
Yes. So
she would not have known unless she herself read the record, the dockets, because you did not take her through the entire contents of the dockets yourself. That's the question.
That is correct, yes.
Yes. And would I be correct to say that otherwise she would have told us that Annex SR5 was not part and parcel of the report that ultimately made its way to her?
That is correct, yes.
Yes. Okay.
Follow up on that. Advocate Mtsweni. Advocate Riley, we all know that the NPA's life as an institution is evinced by the documents that are found in that institution. Is it correct?
That is correct, yes.
that documents are actually the soul and life of any institution. Now, when you talk about having these presentations that you were making, and anyone that comes thereafter does not find any record of such, or any comprehensive and intelligent report that augments the report that you gave to Advocate Batohi, of what good will that information be to the institution?
The only aspect that I can rely on is, as I indicated before, are the communications in which he interrogated the report further afterwards. But I do understand what you're indicating in terms of the presentation. I agree.
What do you agree to? The question that I've asked is, of what good will that be? Because now it means part of the life and soul is missing for anyone that comes generations thereafter to this institution.
I agree with your submission that for future persons, they will not have access to that information.
Thank you, except for the fact that you say it's my submission. I'm not making submissions. I'm seeking for information. Thank you.
Sorry, I apologize.
Advocate Mchweni, now that you went directly to SR5 in relation to my previous question, I would like us to go back to it, Advocate Riley. SR5. If you can take me through the work document and indicate the case numbers in respect of which ballistic reports had been filed and which you considered. Can you quickly go through your SR5, your working document? We can tick the boxes in each of those case numbers on your work document, SR5.
Madam Chair, without being disrespectful, can I ask while she does that we take a comfort break? I could also use some stretching.
Yes, indeed. My sister had actually asked me, as we adjourn now, Madam Riley, do go through your work document and you can tick all those case numbers in respect of which ballistic reports were filed and which you considered as you were preparing the report. We will take a short 15 minutes adjournment until 4:30. When we reconvene, you will then take us through to that work document. Remember, you are under oath as we adjourn. We will adjourn for 15 minutes. Thank you, Advocate Riley. Advocate Riley, you continue to be under oath. Advocate Riley. Advocate Riley.
I confirm, Madam Chair.
You continue to be under oath.
I confirm, Madam Chair.
Thank you. Proceed, Counsel.
Yes. Advocate Riley, before we adjourned, you were asked by the chairperson to go through the dockets that you summarized in SR5 and identify the dockets wherein there were ballistic reports, irrespective of the author there, be it Mr. Stale or Captain Mangena. Have you been able to do that?
That is correct.
Yes. And are you able to identify them for the panel?
That is correct. Yes, that is correct.
Please do so.
SR 1086, the Kwadukuza case, 39 of. I confirm that there was a ballistic report in that docket.
You can take us to the SR page number to find that docket.
It's on the first page, SR 1086.
Where does the work document refer to the ballistic report and of who? Or by whom?
I refer to, according to Mostert A2, was an Chanko AK-47, R4 and I5 cartridges were found on the murder scene. This is confirmed by the ballistic report. Then also on...
Where are you reading? SR?
SR 1086.
86. Whose report was that?
This was a report in the matter where the deceased was Lindelani Buthelezi.
Whose ballistic report was that?
I did not write in my work document, I did not write the name of the ballistic expert.
And you still don't remember who it was?
I don't remember. It's a long time, Madam Chair. It was in 2019. If I go back to the docket, I will be able to confirm.
Advocate Riley, you say
Yes.
at SR 1086, that's where we will find that something is confirmed by the ballistic report. That
is correct, yes.
That would be in paragraph 1.
That is correct, yes.
But if you look at that sentence, it starts at, according to Mostert A2, who was on the Tonto murder crime scene, AK-47 and R4 and R5 cartridges were found on the murder scene of Tonto. This is confirmed by the ballistic report.
That is correct, yes.
And here you are dealing with the Kwadukuza CAS 39/09 of 2008.
That is correct, yes.
So are you saying this confirmation by the ballistic report refers to the case where the deceased is Lindelani Buthelezi, or it refers to the case where the deceased is Superintendent Tonto? If you read that paragraph.
Lindelani Buthelezi.
Then maybe I'm more confused.
Advocate Riley,
I'm also confused. Maybe you are not confused, Council, if you can clarify that aspect. If you look at that show summary, 1086, you read it in conjunction with 1087.
Advocate Riley, we know that
Yes,
I had referred you earlier to the Kwamapumulo docket, the 99 one. Do you recall that?
that is correct, yes.
And that is
That is correct, yes.
the one that deals with the matter of Superintendent Konko.
That is correct, yes.
And yet, in your summation of the Kwatukuza, you make reference to Mostert, who was on the murder scene of Konko, and make reference to the fact that there were cartridges of AK-47s, R4 and R5. Now, do you get the confusion that you talk about? You're talking about the cartridges in relation to the Konko murder in the Lendelane Buthelezi case.
That is correct, yes.
So, would you then confirm
So
that
it was
that it is
yeah, it was also
your summation there is incorrect?
Let me just read it again. That is correct, yes.
So that is not correct.
What is correct, Council? Advocate Riley?
I think it is correct in terms of it's a reference to the Chonko murder, because on SR 1091, I then refer to the ballistic evidence in the Kwadukuza case, 3909 of 2008.
Second case, in relation to which a ballistic report was filed in the dockets and considered by yourself and your colleagues, the DECOC team.
Can you just repeat that question, Madam Chair?
You remember we are dealing with your annexure SR5.
That is correct,
We
yes.
are trying to ascertain from you as to which case numbers, according to your work document, contained ballistic reports that you considered, and you are taking us through that list, that work document, to indicate to us those case numbers in relation to which ballistic reports were filed. Do you remember
That is
the question?
correct, yes.
Yes.
Yeah.
So just indicate to us, you have referred to the Konko Kwamapumulo case number. And the second one?
Second one is on SR 1089.
Where do we find that in your list?
On paragraph 2.
Advocate,
Where
maybe in fairness to you, Advocate Riley, in fairness to you,
yes.
I'm going to park this question. When we adjourn later this evening, you should make a list of those cases because it may be
Okay.
difficult for you to go through your work documents and answer my question. Tonight, look at the work method document and pinpoint to those cases that you dealt with in respect of which ballistic reports were filed.
I'll do so, Madam Chair.
And in respect of which those reports were considered by your team. If you can do that tonight, then we will continue. Otherwise, we seem to be taking long in identifying those cases. Advocate Motswena, remember first thing tomorrow to go through the list that have been prepared by the witness, and then you take us through to those pages. This exercise is taking long.
Yes.
But would like to have answers to the questions that I asked the witness, because I want to make follow-up questions. Thank you.
Advocate Riley, just one aspect that has been bugging me that I just need clarity on. In your mandate as the panel, you were asked to analyze the evidence that was contained in the docket in order to advise Advocate Batoyi whether or not there were prospects or there was evidence or not of successfully prosecuting Major General Boysens. Do you recall that part? Can you hear me? She has frozen.
Yes.
Yes. Did you get the question?
Yes.
Yes, I'm going to repeat. You're saying that...
I said,
Please repeat the question for the witness.
I'm saying that when we went through the mandate of the panel, you were requested as the panel to analyze the evidence that was contained in the dockets in order to advise Advocate Batoyi on the sufficiency or whatever of the evidence. Do you recall that part?
that is correct, yes.
Yes. And we now know that on your evidence, you analyzed and summarized the evidence in Annexure SR 5.
That is correct, yes.
Yes. And on what you told us, Annexure SR 5 was a working document, meaning that it was drafted before you started drafting the report.
That is correct, yes.
Yes. And when one reads it, it goes into detail of each and every case, except for now we know that there was a mistake in your summation of the Watuguza. But what you do is you analyze each case and identify the shortcomings in each and every case. Is that correct?
That is correct, yes.
Yes. And yet we do not
That is
find
correct, yes.
that detailed analysis in the report. Why didn't you as a panel, because this report, the SR5, was already in existence, did you not just simply either cut and paste or repeat it in your report, so that at least you would have delivered on the first part of your mandate being to review and analyze the evidence?
It was a summation of the evidence that we analyzed, the dockets that we even analyze in the report. I agree it does not contain an analysis that we did in the Word document, but we would then, it's a summation of the evidence that after we read the dockets, we highlight in this reporting certain aspects of the dockets, where we, for example, find that the financial, that in some of the dockets, people were incorrectly charged we used the word document, not to refer to each and every case, but to refer to some of the cases and to explain why we say that the dockets were, for example, not properly investigated, or there was still investigation outstanding.
Do you have a question, Madam Chair?
Yes. As Council is asking you, shouldn't you in the report have done a blow-by-blow, full, detailed analysis of the contents of the dockets? Because you've been asked to analyze the dockets, the content, the evidence in the dockets.
We've been asked to say whether the racketeering authorizations, whether there was sufficient evidence to authorize those racketeering authorizations.
That necessitated, I beg your pardon, that necessitated a proper analysis of the contents of the docket. Am I correct?
That is in terms of whether there was a pattern of racketeering activity, which is one of the...
Just please answer the question. The question is whether that which you were asked to do necessitated a full analysis, a detailed analysis of the contents of the dockets.
That is correct, yes.
You did not do that, am I correct? Given the very brief summaries that you give in your report?
That is correct. It was not contained in the report.
Thank you.
Thank you, Madam Chair.
If I may, Madam, any reader who would have come across your report and read that report would not have been apprised of the true reflection of the evidence in the dockets, because this was just a cryptic summary of the evidence in the dockets. Am I correct?
The evidence in the dockets we had to analyze to get to whether the authorizations were validly granted. And I agree that we did not, whoever's going to read it is not going to find a blow-by-blow account of each and every docket or the evidence in that docket.
Will this report therefore have assisted a reader who subsequently did not read the dockets himself or herself?
The reader, because it was submitted to the NDPP on the question of whether there was sufficient evidence.
Advocate Riley, please listen to the question and answer the question. The question is whether your cryptic reports in relation to the contents of the docket would not have assisted the reader who did not read those dockets herself or himself, because the details would not have been included in your summaries.
Of what is in the dockets, yes.
Do you agree that your report will therefore not have assisted the reader or the requester?
As I indicated before, we had a presentation to the NDPP, and we discussed for practically a whole day. We went through the report as well as any other evidence that you wanted to hear, which included discussions on certain dockets.
I understand that, Council. I'm asking you about the report itself. because that which was presented to the president was not a presentation, it was the report by your team, including yourself. That's why we are focusing on this report. Therefore, and I repeat my question, will this brief summary of your report have assisted the requester in making a decision whether the racketeering authorization ought to have been invalidated or not, without the full details of the analysis? Is my question, would you like me to
I do not agree. I think the report deals with our mandate, and the report deals with the issue at hand as to whether, I understand the question, but I do not agree in terms of the presentation to the NDPP, or whether there was sufficient evidence to grant the authorization. So we discussed at length, for example, in terms of Section 21E, we also discussed what was the evidence, what was the requirements in terms of those sections, and whether it has been met by the evidence that we have read in our work document, which is contained in the work document.
I thought that you have just agreed that the report is wanting in details, because it's simply a cryptic. Listen to me first. Let me finish. Because your report in relation to those cases was just a mere summary. That does not even deal with the ballistic reports, for instance. And I'm saying to you, will this report have assisted the requester in deciding whether the authorization certificates ought to have been invalidated or not?
I understand the question.
Put aside the question of presentation. We'll come to that. Let's focus on the report itself. By a mere reading of this report, you may answer, Madam.
The requester was the NDPP, and she gave us a specific mandate. The mandate was to determine whether, in terms of Section 21E and 21F, those authorizations were properly granted or whether there was sufficient evidence. So when we actually presented and we discussed our report, we discussed it in the context of 21E and 21F. What was the evidence in respect of 21E and 21F? So we did not give I agree, we did not give a blow-by-blow account of all the predicate offences, but we discussed some of the cases in the context of 21E and 21F. What was the evidence?
I don't understand your answer. You have just indicated to us that your report, and I'm going to be very slow, as you can read it even now, your report gives a very brief summary in relation to each of those cases. Do you agree?
I agree. I said it several times already. Yes, I do agree. We don't discuss all the cases.
Yes. I'm trying to understand your answers because you don't answer my questions. And my question is, a reader or a requester who asked you to prepare, to analyze the contents of the docket, will she have had the benefit of the details of the dockets upon her reading of your summary in the report? In other words, will the report itself have assisted her, given the fact that the requester would not have read, as we know now, Advocate Batoyi did not read the dockets. She said so. My question is, would your report therefore have been helpful to her, given that it gives just simply a synopsis of the contents of the dockets?
We discussed the dockets in the context of the 21E and 21F.
Well, we don't want to answer
Whether
the
there
question.
was,
I don't think we should go back there. It appears to me it's either you don't understand the question or you don't want to answer it.
I do understand the question, and I do make the admission that we did not give a blow-by-blow account of the dockets or summary of the dockets, because that was not required. The requirements were that we had to discuss it in a context of whether the authorizations were validly granted and what was the evidence in respect of those charges. And that's how we discussed it.
It will be helpful if you can listen to the questions and just answer the questions. Please do that. You may proceed, Advocate Ntweni.
Thank you. Advocate Riley, I know that in your statement under paragraph 51, you deal with the panel's analysis of the law relating to racketeering. But there is one aspect that I want us to deal with before we go into that part.
Which paragraph, Counsel?
At paragraph 54, but I'm just want to close up on the previous chapter. Advocate Riley, the report, Annexure SR1, is, if one looks at it, is signed on the 28th June 2019. Do you confirm that by Advocate de Kock?
It is correct, yes.
Yes. And the reason I'm asking you this so that we get clarity for the record is that at paragraph 51, it's now starting at paragraph 50, you tell us that after your second meeting where you had made your deliberations, there was a draft report that was circulated amongst the members on the 25th of June 2019. Do you see that?
That is correct, yes.
And meaning that the document that was being circulated was not a final document.
That is correct, yes, on the 25th of June. That is correct.
And you tell us then at paragraph 51 that on the 28th of June, the draft report was sent to the NDPP.
That is correct. It's between that time period that we were working on any further comments from the panel members, further issues, further comments on the law or whatever needed to be inserted further into the report. That was between the 5th and the 28th.
Was it at all times the understanding of the panel members that that document was a draft and that the panel would meet on the 1st of July in order to finalize it?
That is correct, yes.
Now, yet we see the document being sent to Advocate Batoyi on the 28th, and it is signed by Advocate de Kock.
That is correct, yes.
And Advocate de Kock, in his signature, in signing the report, signs it on behalf of everyone. Do you see that? That would be at SR10137.
That is correct, yes.
Now, do you have any idea as to how and why would Advocate de Kock circulate a draft to Advocate Batoyi?
A draft report was sent, but we also met on the 1st of July just to discuss the report again, as well as our presentation that we're going to make to the NDPP, which is the next day in Cape Town.
Yes, but the question is, do you have any, if you do not know, ma'am, please tell us, do you have any explanation why would Advocate de Kock, knowing fully well that the document in his inbox was a draft, would sign it and send it to the DPP when he knew that there was a meeting where this scheduled for the 1st, where the meeting where the document would be finalized?
If I understood it, that wasn't a signed report that was sent to the NDPP's office.
Now, ma'am, the reason because if I add SR 0137.
Just repeat that, sir.
Page SR 0137.
Yes.
You would see there it is dated 28th June 2019.
That is correct, yes.
And that is the date on which you say the draft report was sent to Advocate Batoy.
That is correct, yes.
And if you look at it, Advocate de Kock signs on everyone's behalf. That is yourself, Advocate Tenga, and Advocate Mamabolo.
That is correct, yes.
And are you saying that that is not the report that was sent to Advocate Batoy?
It is the report, but what I have is a copy, an unsigned copy.
No, I'm saying, are you on SR 0137?
That is correct, yes.
It contains a signature. Do you see that?
That is correct, yes.
Yes. Now, so therefore the report is signed.
That is correct, yes.
And that is the report that you're saying was sent to Advocate Batoy on the 28th.
That is correct, yes.
And at that date, everyone else understood that it was still a draft.
That is correct, yes.
Now, if you are, hence I'm asking you, ma'am, if you are able to, I know you can't speak for Advocate de Kock, he's not here to speak for himself, but to the extent that you are able to shed any light, please do so. Are you able to shed any light as to why would Advocate de Kock sign a draft document, knowing very well that it is a draft, purportedly on behalf of everyone else, and send it to Advocate Batoy? Would you know of the reason?
No, I don't know.
Yes. Now,
Advocate, Advocate Riley,
Yes.
do you accept and acknowledge this report that is on SR1 as your report? We put otherwise, Advocate de Kock was actually authorized to sign this report on behalf of yourself and your fellow panelists.
It is correct as the chairperson.
As the chairperson. And
That is correct.
yeah. So it was also then sent with your blessing to
It is correct, yes.
to advocate. But why do you always anticipate? The only good thing is that you anticipate correctly what the end of the question will be. But that's fine. So it is correct that it was done with your blessing, it is your report, and further that it was to be sent to Advocate Batohi, right?
It is correct, yes.
Yeah. And when one looks on the first page at SR 0042, the date on which maybe you agreed about this report and how it would be handled would be the 27th day of June 2019. Do you see that?
That is correct, yes.
And the date on which he signed and maybe sent, it's a day thereafter, the 28th of June.
That is correct.
Okay. He acted with mandate. That is fine. Thank you. Advocate Mtsweni, you may proceed.
Yes. Whilst on the report, there was, I think there was evidence of another report that contains two signatures, that of Advocate Mamabolo and Advocate de Kock. Do you recall seeing that report?
You've shown it to me, yes.
Now, do you know as to when did Advocate Mamabolo sign the report?
No, I don't know. I can't say. The only thing I can say is Advocate de Kock's signatures there, and it doesn't really make provision for someone else to sign because there's no line there and it says on behalf. So I can't say when he signed it.
Yes. Now, you said you then met on the 1st of July to finalize the report,
Yes.
although it had
Yes.
already been sent to the NDPP. During
That
your
is correct.
meeting, during the finalization meeting, were there any other changes made to the report?
To the report signed by Advocate de Kock? No.
Now, the report that you guys considered on the 1st of July, were there any other changes?
No.
Yes, so the report remained the same.
That is correct, yes.
Yes. Now, was the report ever brought to you for a signature?
No.
Yes. Okay. Okay, now that we've closed that chapter, can we move on?
Open the door half. Let's not close the chapter. I need some clarity. When you answered the question of Advocate Mtsweni about the report that was signed or that is signed by Advocate de Kock and Advocate Mamabolo, I heard you say, yes, you saw that report that Advocate Mtsweni showed you. Had you ever had sight of that report before, or did you only see it at the time when Advocate Mtsweni showed you?
This one I have not had sight of. The one signed by both Advocate de Kock and Advocate Mamabolo.
Okay, so you only saw it for the first time when Advocate Mtsweni showed it to you.
That is correct, yes.
Thank you.
May I proceed, Madam Chair? Now, let's then move on to the next chapter, where you now go into the nitty-gritty of your report. That is the racketeering charges. And from paragraph 54 to 56, you summarize the elements of both the racketeering charges for contravention of section 21E and 21F. Is that correct?
That is correct, yes.
And you tell us that for the purposes of section 21E, the following elements must be proven. Firstly, that there was an enterprise and that the enterprise had engaged in 2 or more racketeering activities and that the accused participated in the activities of the enterprise.
It's correct.
And then you say, for the purpose of section 21EF, you also repeat that there must have been an enterprise and that the enterprise had engaged in 2 or more racketeering activities and that the accused had managed the activities of the enterprise.
Right.
And then at paragraph 57 to 61, you discuss the characteristics of an enterprise. Do you see
That is
that?
correct. Yes. That
Can
is
you just summarize that for the purpose of the panel?
Section paragraph 51 or 58.
Starting from 57, going all the way, how the Act defines an enterprise and what you regard as the characteristics and what you understood to be the authority for the proposition that you say that an enterprise must, the authority for the proposition on the characteristics of the enterprise.
So in terms of section 1 of POCA, you only look at the definition, and there you get the definition of an enterprise, which is an individual. It can be a partnership, a corporation, association, or other juristic person or legal entity. Or it can be a union or a group of people that are associated, in fact, although not a juristic person or legal entity. That's where we get the definition of it. In terms of what constitutes an enterprise, we ordinarily would look at certain characteristics, which is there is in the enterprise you will have a different differentiation of roles. There's ordinarily a system of command. The group will ordinarily in the enterprise have a common or shared goal or purpose, although it's not a requirement. Sometimes there's an intention to profit from your activities, and then what is very important is the continuity of your personnel. In other words, you can't have a situation where you have one person and then, or 2 people, and then one leaves, and then you have another person coming in. It can happen in that way, but your grouping or your criminal network must continue to have continuity.
Okay, and then at paragraph 59, you deal with how one proves, you deal with the separation or the distinction between an enterprise as well as the existence of a racketeering, of a pattern of racketeering. Can you elaborate on that?
In terms of your enterprise, ordinarily it's separate from your pattern of racketeering. So the type of evidence that you will look at is in terms of, is different. But I do understand that sometimes your pattern of racketeering activity can also establish or maybe establish the existence of a enterprise. Then the enterprise exists then separately from your pattern of racketeering activity.
Okay, and then you then continue to deal with what needs to be proven for participation. Please elaborate on that.
Before that, did you look at the jurisprudence in South Africa dealing with these aspects in relation to the existence of the enterprise? I see you only refer to foreign jurisprudence.
Yes, we have. Advocate Mama Bola, one of his tasks was to compile a report on the legislation dealing, amongst other things, with racketeering as well as hearsay evidence in terms of Section 2, subsection 2 of POCA, where it can be regarded as admissible evidence. So we did look at other case laws, South African case laws, such as Jawara, I think the De Vries decision, the Savoy decision, as well as the ASIN decision.
But none of these authorities you are talking about are reflected in your report.
That is correct, yes.
Why so?
I do not have an answer for that.
I would imagine,
Yeah.
Given the fact that this complex legislation, the POCA, resulted in case law in this country. I would imagine that as someone who kind of specializes in that legislation, given your resume, you would have gone directly into the South African jurisprudence as regards
Sorry, it's breaking up. I can't hear you, Madam Chair.
I'm saying I would imagine that you would have gone straight into the South African jurisprudence in relation to this piece of legislation, POCA, instead of
That is correct, yes.
relying entirely on foreign jurisprudence, as you did. Is there any reason why you did not refer to case law in South Africa in that regard, particularly in your report?
There's no specific reason. I can't give any specific reason. And I do agree with what you have to say, Madam Chair. We could have referred to South African law as well.
And you do agree that our law on POCA is not identical to the laws of America have referred to, or case law in particular?
In some cases, yes.
There are distinguishing factors.
That is correct, yes.
And hence the development of our own jurisprudence.
That is correct, yes. I agree with that. Not in all the cases, but in some cases, yes.
Thank you.
May I continue, Madam Chair? Yes, you then add paragraph 62 and 3, give a brief summary as to the element of participation. Can you just summarize that?
What the state has to prove is that the accused, through his conduct of some form, participated in the affairs of the enterprise through racketeering. Ordinarily, you will look through that in your pattern of racketeering activity. We do say it can be either direct or indirect, but must be causally connected through the affairs of the enterprise. In other words, there must be a connection to the affairs of the enterprise in terms of your pattern of racketeering activity, although distinct from one another.
Yes. And then you then go on at paragraph 64 to 66 to deal with the characteristics, or what is it that the state needs to prove to demonstrate a pattern of racketeering. Can you just also elaborate on that briefly?
A pattern of racketeering is the planned, ongoing, continuous or repeated participation and or involvement in any offence referred to in Schedule 1, and includes at least 2 offences referred to in Schedule 1, of which one of the offences occurred after the commencement of this Act, and the last offence occurred within 10 years after the commission of such offence. Such prior offence referred to in Schedule 1. Then on it's paragraph 65, I list we listed a number of taken into account whether, if you want to determine whether a pattern of racketeering existed. So, as in this case, you would look, for example, at the number and variety of predicate offences, the length of time over which these offences or acts were committed, and the number of victims and accused injured by similar acts. You would look at similarity of offences and the character of the unlawful activity. So in other words, one would, for example, really look at a pattern. And I think in this regard, it was said that the Kekana group, in terms of their pattern of racketeering activity, that they were committing murders for rewards. So that will be in terms of these 23 dockets. Is there any similarity of the offences? And then obviously one would also look at the length of time over which these acts were committed and the number of predicate offences. Then in terms of paragraph 66, it is required at least 2 acts of racketeering activity. And in terms of section 21F, we say that in addition to the enterprise and a pattern of racketeering, to prove that the accused managed or was employed or was associated with the enterprise.
Yes.
And then we mentioned the fact that in terms of 21F, which also differs from the United States, the RICO Act, our sections, as pronounced in terms of our court, in particular the Savoy decision, that knowledge of an accused to be found guilty of management. So it is not necessary that you prove that this person was actually on the crime scene or committed these acts. If you merely have knowledge, or he must or ought to have reasonably known that another person was engaged in a pattern of racketeering activity. So therefore knowledge and not participation is required. We also said that manage to what is to manage is not defined. One must defer it to its ordinary meaning, which is to be in charge or supervise. And then we said we examine the evidence at the hand of what we said, what is the law, whether there was sufficient evidence for successful prosecution on charges of racketeering.
Yes. And then
Advocate, before you proceed, at paragraph 68, Advocate Riley.
Yes.
You're saying mere knowledge and not
Yes.
participation is enough for someone to be convicted or to be found guilty of management. Now,
Yes, in terms of
in layman's terms, it means you do not have to place a particular person at the scene of crime at that time, but you just have to prove that this particular person knew of that crime, even though they were not at the scene, for them to be charged with a crime of management.
in 21F, yes, I agree.
Thank you.
yes. Just a moment, Madam Chair. You then, after you had analyzed these principles and against the backdrop thereof, you then went on to analyze the evidence in order to determine whether that evidence does live up, can be sufficient to sustain a prosecution on the racketeering charges. Is that correct?
That is correct, yes.
Yes. And when you start in the starting point.
Advocate Mshweni, I think this takes us to the report itself. Am I correct?
That's correct, Madam Chair.
We consider that before she starts on the analysis as regards the report, we can pause and start with that tomorrow morning.
Thank you, Madam Chair.
In other words, you'll start from paragraph 71 tomorrow and take us to the report. Advocate Riley.
Yes, Madam Chair.
We think that we should adjourn now. It's 5:30. That will afford you an opportunity to do that little homework that I mentioned earlier
I'll do so, Madam Chair.
tonight. And so that when we start tomorrow, we start with that and then proceed with your analysis.
Thank you. I'll do so.
We are going to start tomorrow at 9 o'clock. Will that suit you?
It's fine, Madam Chair. I'll be here.
Yes, thank you. And I hope that we will not encounter challenges we encountered today in relation to your setting up wherever you are. We are told
I'm
that
not sure that everything is.
yes, we are told that Advocate Lekheto is not far from you. Advocate Mtsweni will tell her to make sure that the setup is properly done so that we don't get disrupted tomorrow.
Thank you, Madam Chair.
Yes, thank you.
She is close by.
Advocate Mtsweni, Advocate Kaitovi, we propose that we adjourn now until tomorrow morning at 9 o'clock. Madam, you are still under oath until tomorrow. We adjourn.
Thank you.